A wild goose chase, the beginning of the problems of the Supreme Court bench?
I don't think so. I don't think so because I'll give you two reasons. Number one, the two leading proponents of the process have accused each other before of bribing judges. They are on record, but they don't want us to say that. The two leading proponents of that campaign, Maringa, have openly accused each other that we know you have been bribing judges. And the other says, we know you have been bribing judges. If for any reason, I am not making any arguments, Maringa, I have never made any argument that the judiciary is without challenges. The judiciary is with challenges. I have criticized the Supreme Court consistently. Why? I would give you two reasons. Number one, the Supreme Court has been so inconsistent in its decision making. The Supreme Court tells you this today, the Supreme Court wakes up tomorrow and tells you this is the position of the law, and the next day it tells you this is the position of the law. But my point of disagreement with the entire of this process, Maringa, is if we are reforming the judiciary, let us have an honest conversation that is not being hijacked by political interest. And this is why I have said many times that we must purge the purgers. The purgers don't want to be purged. People of questionable professional ethical conduct have come to lead the process. We are not saying this, the judiciary has no problem. We are not even saying the Supreme Court has no challenges. But we are saying that you cannot remove judges merely for the merit of their decisions. Errors, as my colleague have said, in judicial decision making, go through the normal appellate process for correction. And I know this becomes complicated for the Supreme Court because if the Supreme Court as they add in the Ahmed Nasir issue where they told Ahmed Nasir, you are permanently barred plus your 20 associates. I've said it was wrong. I mean, the right to fair hearing is one of the most basic rights. And even if in case Ahmed Nasir had undergone...
because even you can't hear his stuff. I mean, what logic is that?
Yeah, so assuming that he had vilified the court and the court was so enraged and he had undergone the entire process, what was the issue of barring the 20 associates? But I'm saying we cannot remove them merely because of that, because the High Court has also told us that the standard of incompetence, Maringa, as a ground of removal, you can't isolate one decision or one act of a judge and say, because of this single act of a judge, let us remove the judge for incompetence. You must have a series of line of mistakes of this judge that goes to their professional competence and then say, from the totality of these decisions, we can then conclude that, this judge is corrupt or should be removed from office. Okay. Number two, and lastly, it is not conceivable, and I've argued this all the time, it is not conceivable that you can through a blanket process, remove an entire Supreme Court bench. I think one of the mistakes that happened in these petitions that have been forwarded before the GAC is that they are not particularized at the mistake of each and every judge, Maringa. We have just been told that all the 7 judges of the Supreme Court should go. We are not being told what was the role of Justice Lenaola in this and this and this. We are not being told what was the role of Chief Justice Koome in this and this and this. We are not being told. We are just being told blanketly that, look, the judiciary is corrupt. We are being told blanketly, look, the entire Supreme Court, the common quote of juris pesa. The point is that, Maringa, we may have mistakes with the judiciary, but judicial independence must be protected. 2 great jurists, the former Chief Justice, Felix Frankfurt, one of the US Supreme Court judges, he actually made a very, very important argument, as well as the former Chief Justice of Israel, Aharon Barak. He made an argument that judicial independence, Maringa, is not a privilege of judges, but it is a right of the people. If, for instance, today we wake up and say that I can remove a High Court judge because they disagreed with me on the law, the question is, how far can we go? And who is to make that determination? Is JAC going every time a judge makes an erroneous decision? Is JAC going to interrogate that decision and say, you did not reach a favorable consideration as we thought or as you ought to have been? What is the yardstick? How far can we go, Maringa? There could be incompetent decisions. There could be blatantly incompetent decisions, as my colleague has said.
Yes.
But I've always said that the route cannot be to open the Pandora box of allowing JSC to review those decisions.
But we